Yes.
My lord,
Don't mention, because I find there are 60 matters which are still pending to be listed. Let me dispose of those 60 matters first, then I will accept all the mentioning. Don't burden it unnecessarily. It will wait for 1 month or so. You will come that you have mentioned twice, thrice, 4 times. Unnecessarily we can't. Yesterday just I checked.
this is the Supreme Court remand matter. Your lordship knows it. I'm just submitting the memo. Your lordship
Yes,
will pass
we
it.
will consider it. Don't worry. It will come. It'll come. Don't worry. We'll take up. Don't mention the matter unless it can't wait for a day or two.
That's the urgency.
But-
Matter can become infructuous any moment.
Yes, moment. It's not there. It will be listed. It was listed earlier.
No minutes. Fresh.
First time. Fresh, it will automatically come. Don't worry.
Minutes.
Got-
Fresh matters will automatically come. Don't worry. I've already indicated. Yes, call the list.
For judgment,
Letter.
WS 629 of 2025.
The impugned judgment is set aside. The appeal is allowed. Yes.
Item number 1, WPC 3307748.
It is state emblem matter.
What has happened to you?
It's not like this. What happened in this matter? I'm not.
They are challenging a blacklisting order.
No one. They are saying.
Where is this annexure 10?
But they are saying that it is also a fact. Somewhere the emblem was fixed not with a proper manner. It is admitted.
What?
That's the problem. The emblem was used.
Oh, emblems.
Yes. This emblem was used by some of the organizations or department debating some. In that part, I am considering with my learned friend and this petitioner who is alleging some point. In the precautionary measure, the government has issued a circular to all the chief secretaries that these are the conditions if you violate tax stringent action in this regard. Number 1. Number 2, in the meanwhile, there is on the statute there is a penal provision, 2 years and 5,000 on this thing. Hard issue is that self dealt by the Honorable Court of Karnataka, High Court, and there preserves some points. If addition to that, my lord has given a direction, we are ready and willing to abide for this.
The lordships, the state emblem was taken in 26 January 1950, and thereafter,
We need not have to argue what he is conceded.
yes, your
Yes,
lordship,
there is an
consider it.
emblem act. There is an emblem act. They have already issued the circular to all the.
Your lordship,
Department.
they issue circular from
Now we have to see whether they are simply kept in a they are simply kept in a cupboard or it is activated. This is what we wanted. Where is the Karnataka judgment?
Your lordships, please give me a 1 minute, your lordships. I place the matter only rejoinder appeal, only rejoinder appeal. But they are taken the actions. I only elaborate before this, your lordships. What is their take actions are involved. I have heard your lordships. That is not maintainable. Because your lordships, they allege in their counter affidavit, they rectify 7 places in the states, the state of India. But your lordships, out of the 6 places, are not permitted as per rules to the state emblem of India is present on them. Only they are rectified that they written the Satyameva Jayate below of the state emblem of India. After your lordships, another point I have issued your lordships in April that a panchayat office is used by state of India. Your lordships in Rule 10(2), there are specific provisions that the college, the university, the bank, the private sector, the panchayat office cannot use. They file the counter affidavit, only rectify that they written the Satyameva Jayate below the emblem, your lordships. Even that, your lordships, all over the states, in all over the country, there have several violations. In before lordships, our front of our High Court is the Langa police stations. There are violations, your lordships. They take actions, but the action is only a pen and paper. I pray your lordships. What is my prayer? I pray three things, your lordships.
That is what I really wanted, that please, this is a public interest
Yes,
litigation.
your lordship.
You should know your limitations, that what to argue and what not to argue.
Yes.
You are a public spirited person. Please come that what should be the modalities which the state should adopt in order to ensure the strict implementation of the Emblem Act. You are not going to castigate what they are doing, what they are not doing. It's not adversarial litigations. Let us come with one positive suggestions from your end. Give us that these are the requirements of law, and this is what they have to follow. Give us.
Your lordships,
We are ready to accept that.
I pray that
You are castigating, they are doing this. This is not a way a public interest litigation is argued. Come with a positive
Your lordships, I pray for the-
intention. Come.
kindly have a glass of my prayer, your lordships. Prayer number-
What is a prayer? We don't.
My prayer
Now
is that-
tell me that what are your thing, that how positive way or what should be the steps to be taken to ensure the strict compliance. Give us.
If your lordships, they are published the state emblem in textbooks of school, your lordships, which is permissible as per the rule, then maybe the citizens are aware. Because your lordships, maximum citizens are not aware. It is the positive
So
things, your
that is
lordships.
why there must be some kind of a guideline that should
Yes, sir,
that should come, that how this particular notion can be spread over.
Your lordships,
What should be the modalities? Whether the schools should be apprised of this. Tell us that what steps should be taken.
your lordships kindly see in the clause 15, schedule 3 of
Let you give the suggestions that what should
your lordships, 1 minute, please, I pray.
Because you are asking like an adversarial litigant.
I am not adversing your lordships. 1 minute, your lordships. I pray seek your lordships on my rule, your lordships. Clause
I am
15.
asking, sir, do you not understand the pulse of the bench?
Your lordship.
Irony of the thing is, at the very outset, I said, that these are the steps which should be ensured by the state in order to keep that law in place. Give us that what should be the modalities to be adopted.
Your lordships, already there have the acts and rules, but that acts is not strictly
I understand.
implemented.
I understand now. Can I appoint any MS plus QD to advise that what should be? We are there. Because the
Your lordships,
you are
before
arguing,
appointment, only clause 15,
you are
your lordships.
arguing in this fashion, then it's better to have that. But as the Supreme Court in many of these cases already appoint the MS plus QD. Let them advise that what should be the best way.
Before
Understand, sir. Because there is a rule.
yes, your lordship.
What you want, I tell you, what I perceive. This cannot be done, remove it. This cannot be done, remove it.
I cannot.
I am not of that.
I am not. I am also not of that, your lordship.
Then you say that these are the misuse they are violating. Then how to eradicate this violation? Now, one, that the state must come up and spread this particular notion by going to the schools, by going to the hospitals, there must be a constitution of initiative. The state has also come up, the central has also come up. Yes, there has been some reported things which are going on, which is definitely against the spirit of the Emblem Act. So his concern is that the Sattamayo Jayate, now there are designated places where that can be done and otherwise it cannot be done. So now how to do it? Because randomly those are being used. So can we advise the court that what should be the modalities, what should be the stake, what should be the guidelines, include with the act of the rules to take it, so that it will be a uniform matters that would be issued in the public consultation, or it's strict adherence.
Whatever record I have to submit my not seniors and my friend.
This is what
Yes.
we wanted an amicus curiae to advise the court.
Almost all precautionary measures we have taken. In spite of this,
The difficulty is that despite the law in place, yet nobody is following. Then how to do it? Mere panel provisions is not.
surprise the
You have
court,
to-
yes.
you have to take that panel provision, no, but also just to prevent. There is a distinction between a prevention and there is a distinction between a protection or a prohibition. These are the three coinage of the words.
Yes.
So how we can prevent it is the first motto. Then the question of violation, protection, and the prohibition that comes.
Yes.
I want a preventive measures to be taken to where the rule is silent. He is raising that this rules do it. I understand, prohibited. But how to prevent it? By punishing. That's a one-time exercise, but the people are not aware. How to spread that the people must know that this is what the law is. This is what I am thinking.
Exactly.
Which he is not understanding in this way.
I am also understanding your
You
lordship.
are not, because
Yes,
the
Your
way
Lordship.
you have started, it appears to me that Rule 15 is very clear. This provision is very clear. We understand, that's a correct one. But how measures have to be.
If your lordships have a glance of my prayer, you understand what is my concern.
Prayer, I am having your prayer,
Yes,
and
sir.
the prayer is so cryptic. I am reading that anybody of who is present in the circumstances mentioned above, it is humbly prayed that the High Court may graciously be pleased to quash the letter. Just imagine, quash the letter dated 24/4/2024 and annexure 6 and letter number such and such annexure 9.
No, your lordships, you are wrong file, your lordships.
What wrong file?
I
I am
am,
looking at the file.
no, your lordships, I did not peer it that.
What?
I peer that admitted the petitions rule issue, opposite party show the cause, as why the failure to take steps.
3077 your lordship. 3077.
Oh, this is failed to take steps. Again, you are
Your
saying
lordship, second and third.
and mass
I omit,
how?
I-
How? What should be the modalities? How to spread a mass awareness? Where?
Your lordships,
Then
through,
there must be either in a print media,
yes, your lordship.
either in a visual media,
Yes.
or any other frame by using that particular beating of the drums, by using a microphone,
Here is there.
going into the localities. Who should be involved?
Your lordships
Who
always
should be involved in spreading that particular message?
The issue is very
We don't
important,
know.
but locus standi of the petition also a questionnaire. And that part I don't want to go because it's a very sensitive issue.
Litigation, the locus standi takes a backseat to some
Yes.
extent.
That's why I'm not
If
raising
what
it. It
finds
is a sensitive issue.
Is a matter of
Yes.
great
Both
concern.
this, with the senior counsel will guide the court. We can go accordingly. There is no issue. I will provide all the documents to them. Also, the judgment of the Supreme Karnataka. Yes, yes.
Give them.
Yes, ma'am. Yes, ma'am. What will you do?
I will assist them whatever they report.
The instant public interest litigation is know this expression from Justice Krishna, yes.
Rate is so high, it's very hard.
You are young, I understand your concern, but adversarial litigation, public interest, both are different.
Item number 2.
Yes, ma'am. But I am is a successful tender.
But blacklisted, sir.
Yes, I have been blacklisted without issuing any show cause. That is yes, for 3 years.
Yes. Yes, without show cause. So serious. How can you?
To file a counter affidavit in this matter.
Yes, being that blacklist.
Apparently, there is no instruction.
No, madam. If it is a correct fact that the blacklisting has been done without issuance of the show cause, without giving them an adequate opportunity
My lord.
to know that Parija's case
Yes, my lord.
of the Supreme Court originated from this court. Panda. Panda.
Spondai.
Panda. What to do?
From the
Where
record.
you said that no show cause is.
Yes, madam.
Where you are. Only one, that whether you have issued a show cause.
Yes,
You should only tell us where you have stated.
yes, madam. That's 14.
Paragraph.
The last line, without giving any opportunity of hearing, that's totally illegal.
No, it's the opportunity of hearing is different. Without issuing a show cause notice is different. Do not mingle up both.
That
Tell me whether the show cause was given or not.
no show was given.
Huh?
No show cause.
Where, yes. We order blacklisting the petitioner for a period of 3 years from participating in any future.
On the earlier occasion that I filed the petition,
Yes.
your representation was pending.
For that reason, I approached the Honorable High Court. Honorable High Court directed them to consider that.
So in that.
Without considering that,
In that representation,
I know.
in that earlier round, what was under challenge?
Other ground was the high deposit.
What was under challenge
That is only my representation was pending because it was not considered.
with regard to?
With regard to non-deposit of additional performance security of 1 crore. That is the case.
Anyhow, yes.
Item number 3.
Who's the accused? What is the?
Item number 4, sir.
In fact, in item 4, madam, on behalf of the Odisha Medical Corporation, I have already received the Parvai comment and the documents. Even from the document of the petitioner itself, it will be revealed. One of the primary grievances was the private opposite party will supply the articles which is belonging to prohibited countries bordering these countries. In fact, the documents that have been filed by the petitioner himself will show that those belongs to the plant is in India only and not from any of the bordering countries. I'll file a reply if WhatsApp grants me a week's time only. I have got all documents and everything. I'll demonstrate.
Probably my
petitioner's document only.
Had that, our specific case is that US FDA registration is not there with the opposite party number 2.
It is there.
US FDA registration is the mandatory requirement in the tender document. So from the US FDA registration, they had given it related to Shanghai company, not of this. And they have filed, the Philips India has filed, there is a document which I filed, Melantrate is offering. That document clearly shows that no, we have no connection in Shanghai
You have downloaded certain
Yes,
information
madam.
from the
website.
internet, and then if they have to come, if they have other documents,
Yes.
the
Yeah, but yes,
information
madam.
uploaded in the internet may not be correct all the time.
Yes, my lord. I do not know. Only thing is that
Because those are not retrieved from an official website.
Yes, madam.
but those are
From the
official website, it's from official website.
We don't know. Now there are
But
many websites.
The link is there, my lord.
Shown to be a website of a company, but those are fake.
And we had also intimated them about this.
We have been noticing in the newspaper every day.
My lord, we have also intimated this aspect to the, brought it to the notice of the authorities, that these things are there. They have not considered.
What is their
My lord,
answer to it?
Yes, my lord, I do not.
But they in fact,
They did not
they in
consider,
fact,
they did not
raised
consider
this point for the
objection.
technical committee that was also considered. I'll come back with every document and show it to your lordship. That was raised for the technical committee. And in this sequence of events, your lordship, that was produced on the last occasion by the learned advocate general, which I had in fact passed on, will show that opportunity has been given to both the parties fully, because we have no bias. We are just selecting a, because now the medical colleges have come up. They are being referred to other medical colleges. No instrument is available, ultrasound and other things. So therefore, it has been done with urgency. And your lordship will see the sequence of events. We have given full opportunity to both the parties, and we have considered everything. I will come back with all the documents.
Another aspect is coming.
My,
But when you say that it should be a particular comply,
yes,
the certification from the outside.
it is not.
Another country.
May I just clarify? So far as this,
Why not the press certification should also be included?
may I just point out one thing? The US FDA certificate, only pertains to, I'm sorry. US FDA certificate only pertains to the make and model. So far as the supply is concerned,
Yesterday, there was one matter which played before us. There, the point was that you are basically putting those conditions, that those certification issued by the US or the Central Union, sometimes CU, Central Union,
European Union.
and it offends the very core policy decision of the government of India to promote under the tagline of Make in India. So what was his point of concern was in the earlier matter yesterday, that if we insist for those certifications, then in that event, the manufacturers of those items within the country, they will not be able to participate. So there was a PIS, some concept was introduced that this certification should come included. The technical committee, except there was a notification which was issued, which says that no, you cannot insist for this UDFA or something or a CU, you can't. You have to include those as well. That was given. So in this case, have you included any Indian indigenous certificate
My lord, it is included page 820 and 821 will show. This is based on.
ISO is the different. ISO is a different certification.
I beg to make one distinction. US FDA certificate.
Yes,
Kind person, I just make to one distinction. US FDA certificate is only with regard to the mechanism. So far as the manufacturing and supply is concerned, page 820 and 821 would show it is only in Pune manufactured and under Make in India concept. That certificate also has been given. Page 820 and 8. I'll come back with all the documents. I have everything. I'll assist your
This is what we wanted.
Yes.
Yesterday it was like that.
My, it's only in Make India consent as your lordship has been placed to
And there are
express
two or three
Yeah.
the circulars issued by the Secretary of Government in this regard that you have to insist.
It is in adherence to that only. I'll show that to your lordship, my lord. Only 1 week time, my lord, I'll file. I have got all the documents, everything, my lord, the annexes and everything. I'll just compile it and file it for your lordship's convenience assistance. I'll give to your lordship. That much, my lord.
I'm appearing
My
for
lord.
appeal number 4.
Successful bidder.
That only,
Contract only started actually.
only concern is that let them supply.
Mr. Vishnu appears, it shows successful bidder.
Always,
Not unsuccessful.
always. The other day in BMC also was for the successful bidder.
In fact, everything has been complied with as your lordship wants, but those certificates all they available. I can produce that.
Just for your government.
Sorry, madam? Private company.
It's a mistake in the cost side.
Mistake in the.
My lord, here what has happened, 3 medical colleges were opened.
I understand, sir. Yesterday, we were very serious about it. So far as the health sector is.
No, there's a
concerned,
mistake in cost side.
So far as
I'm sorry.
The well-being of the citizenry.
No, my lord, it is by mistake.
He said that there cannot be any compromise on a quality.
Absolutely.
I think, Mr. Ms. Das, you appear. And we should not accept that. Because we are aware that if any inferior quality materials are used in a health sector, we cannot compromise. Absolutely. A sensible person of the society would accept it.
And if the lordship
And
still
in
the
my case also,
demonstration
I've
and
raised that
everything,
issue. I've raised that issue in specifically 2 representatives and everything. They have not answered it. Technical verification manner, the demonstration manner, they did not show the volume navigation. That also has stated. And not only that, they have stated and they in a bid, they have given one certificate, I'm sorry, one model, and they've taken demonstration, they've given another model. That also have objected. That also doesn't satisfy the requirement. That also have stated in the. I brought it to notice of the authorities on 2 occasions specifically after the bid was opened. Despite that, they declare him eligible. That is the 22nd.
When, how soon you can file?
only a week, my lord, I'll file it. I'm already in the process of getting it finalized. I was trying desperately to get it done by today. I couldn't make it because certain facts are to, and I can assure your lordship, strict adherence to the tender concern has been made. I'll demonstrate from record.
Only consider that they start supplying the instrument. Then it will look in process for week.
With my learned
The contract has already come in.
No, it has already, purchase order has been issued.
Yes. Here.
Let it embark a journey on this terrain. We are not going to.
All the documents are there on record also, and you can see all the requirements.
No, इसे क्या परिवार सर?
Yes. You are for?
I'm for the corporation opposite party number 2.
2000 for the opposite party number 2.
But health sector, they themselves neglected. They themselves neglected.
People of the state
Equal or-
should not be
But equal ownership.
of the health facility.
Well, it is, that is true.
Last-
But your lordship, let us know your lordship will agree that your lordship allows you to consider. Then what will happen to those machines already supplied?
That we will consider.
That will tell.
Not at all. Not at all.
If you order, or any supply will abide by.
Yes, I'll file as per your issue.
Sorted melon.
Dismiss one reference.
Well, sorted melon.
Yes, a sorted. You don't give 1 week rejoinder kit at all. You just delete 1 week.
One week they will file counter. I'll take 2 days time.
Just
But that was ordered.
if you need, then you tell me. Otherwise, sit. Yes.
Item number 5.
Because of force,
Yes.
Yes,
The name would be recorded for some good reasons. Don't worry.
Item 5, sir.
you should permit me to file the documents if so required.
You would be filing those documents.
I'll file everything.
The tender. At least one. The tender, my lord.
I'm filing the counter affidavit.
Friend was in KVR. He's filing a counter with tender for my lord, sir, extremely high value tender, 1,800 and odd crores. And it's a, I'm the bidder who has been.
I value tender.
It's a high value tender. I'm the bidder.
Extremely value.
Normally, we don't get to see 1,800, 1,900 crores tenders in Orissa, my lord. Small state. But I'm the bidder who has been, my lord, I'm the bidder who has been disqualified on the ground that I had submitted the document, but the document was not legible. So my submission before your lordship is that, and they have a safety valve inbuilt in the tender conditions that wherever the documents are not either not uploaded or there is some deficiency in the uploading, they will give 7 days time and they will notify from their end that we have verified your documents and we found that this is the shortcoming with your documents and you are given 7 days time to make good the deficiency or maybe upload the document if you have not uploaded. That is, there's a specific clause. Now that clause itself has a one-liner that virtually takes away to the left hand what it gives to the right hand. It says that supposing even if you don't receive any email or any notice or notification from us, it's an MCL tender, one is the Coalfields tender, even that won't be a plea for you to not take a plea that I could not get a notice. That will not be an excuse against non-submission of.
According to you, the even the service of notice will not be.
Yeah, that is what. So it's something like giving with the right hand what you take away with the left. So I'm my learned friend is filing a counter minutes. I have no difficulty with that. I'll file my reply. I short date. Only minutes.
Me, how soon you can file?
I can file in 4 days. In 4 days. 4 days.
Course of this week.
Minutes.
In course of this week, can
In
you?
course of this week, also I have it on Tuesday minutes.
Because you can file it on a returnable date, but the copy.
I saw a copy. I will
No difficulty.
advance.
We are having a 3 days holiday.
You that is sufficient.
We are keeping it on Tuesday,
Tuesday.
but copy must be given in.
No, in advance.
Where is the counter available?
No, I'm filing it right now. I'm getting. Today I'm filing.
Not for.
Book number 1, 2, 3.
One, 2, 3.
Seven, 8/2025, I think.
Yes, sir.
But order dated 7/8/2025, order number 1.
Yes, sir.
Actually, it's short order, but it has been, the entire matter is given a final shape here by my lords here in this order. Para 3. If my learned friend Mr. Das has come up with that calculation, then it is undeniable that an application was filed at a point of the
Yes,
license.
sir. Have you calculated, sir?
Yes, my lord, up to 31st March 2025, the amount as demanded in the impugned order is 19 lakh 78,295. But as I remember, last occasion, irrespective of what has been reflected in the order, your lordship wanted to know what is the exact amount on the day, on the last date of making the application.
Sorry.
That was what your lordship wanted to know. Because now I have received this instruction. Lordship may kindly have a glance to this instruction. The original copy.
It can be given to me.
Your lordship, para 3 and 4, your lordship may kindly see. Para 3 reflects the figure as in the impugned order. But para 4 reflects the figure as on November 2024. And the exact amount
Right.
and the exact amount as on November.
Sir, there has been a consistent view of this one.
Yes, sir.
That so far as the shortfall is concerned,
Yes, sir.
if you renew the license, with an undertaking that they can make good the shortfall of
Yes,
the
yes.
previous years. In addition to the minimum guaranteed quantity of the subsequent one.
Yes, sir.
So we were talking about a shortfall and has now been noticed.
Yes.
The question is that they wanted a shift in. You
Yes.
have to take a decision.
Yes.
And if they deposit, barring the shortfall.
Yes, that is as on
The shortfall.
as on the date of application for shifting. That is para 4, your lordship
In
will.
barring that, what should be the amount if they?
Yes,
deposit
my
the
lord,
amount,
that is
send the
12.
application and then they will.
Yes, my lord, that is 12,20,956. Just now I received that.
They will deposit that amount.
Let them deposit that amount and
You decide the application within a period of fortnight from the.
yes.
Decide.
That is also the order in the in a similar case, which I have flag marked for my lord's convenience. That is a thing. The only difference was there the license period has expired and application for shifting was there. Here the license has
Was
not
valid.
expired, but the application was made prior.
Yes, that is what.
That was only the short discount.
Correct.
And that order I have flag marked for my lord's.
Yes, it's good.
So the same order, let him deposit this 12 lakh and come out, subject to final outcome.
By an order dated 7/8/2025.
Just like that. 66, 72. It's business.
Item number 7.
There is.
The online application is on.
Your instruction says that they have not intimated.
And there is an intimation, record on the record. Anyhow, we are not.
Item 7.
Or it will be a contested. So I need.
Affair of the applicant to is.
Note 13.
Library, all these three matters will also. The only ground which I have taken is violation of principles of justice.
On the last occasion, my learned senior's argument, your lordship actually shocks to my conscience. Your lordship, after that, your lordship, I personally investigated in the matter and I have paid.
Shock his conscience, that means you understand.
Your lordship, because his client was suffering from cancer. And I know what is the fate, your lordship, because I am also, my mother was died in cancer.
So human being.
Your lordship, so I have examined the entire case record, your lordship, and subsequently, your lordship, many assessment.
That day,
Your lordship, yes.
I'm very sorry. I should not.
Your lordship.
Personally.
Or don't carry.
No, Mr.
Never, it was never meant from the judges at the bench. Don't.
Your lordship. Your lordship, I have.
Only in pursuit of the matter, nothing more than.
Your lordship, personally, I have examined this matter. These matters, your lordship. The last paragraph, your lordship, I kindly looked into. Your lordship, for this instruction, I have called for, and I have perused all the assessment orders, your lordship. On the last occasion, your lordship has asked a question whether it is consequential or the independent proceedings. Your lordship, obviously, these are independent proceedings. So, your lordship, what my respectful submission before your lordship is that on the last occasion, my Lord Senior has given an undertaking that whatever, if it is admissible, the refund is admissible on adjudication. The refund is to be adjusted against the outstanding demand, your lordship. Your lordship, so let this matter be remanded to the assessing officer, your lordship, basing on this instruction, your lordship, and let this matter may not be a precedent. Why, your lordship? Because your lordship admitted delay is there.
Oh, understand, sir. That is what we say because of the peculiarity of the facts. And considering the disease which is suffering.
Each case turns on its own facts.
Your lordship.
No, we will record it. That
That
will not be taken as a
husband of the proprietor.
because the extraordinary and exceptional circumstances involves extraordinary and exceptional decision to be taken.
Your lordship. And in the subsequent assessment, this issue, so far as the IGST particularly, I have examined, this IGST issue has not been adjudicated. It could have been adjudicated, then the matter is something else. And since not adjudicated, for that reason, I have considered and I have taken instruction. Your lordship, grateful and grateful.
All three matter.
Both the grateful to my learned friend and all. For being grateful and
He has to be reasonably long since he has noticed since long, at least I can say I have noticed. My brother has more experience. I am a little bit.
I have experience with assisting Mr. Kala as well as he was also standing for the
Particularly we have seen
so standing.
as the career is also is not that unreasonable.
Gratefully.
Item number 14.
Lordship, by the adjudicated 29/7/2045 in paragraph 4.
but please to direct to obtain instructions, my lord, has to.
We need some more time. I have not received any instructions about it. And just also today also I discussed with the officers. They need 1 week maybe given us. I'll be taking care of.
Item 15.
Two, he also let it be 2 weeks.
My lord,
We have to take instruction from the
My lord.
GSTN also.
10 days.
Item 15.
My lord, it is relating to the allegation against me is clandestine manufacturing and clearance of the acceptable goods, the pan masala. What goods? Pan masala. What is this?
Pan masala, good and pan masala.
Good and pan
The
masala.
way you pronounced, I was shocked. Pan masala.
Pan. So actually, from 2008 onwards, I have the registered SSC under the Central Exchange.
So what brand?
Balaram and Gutka.
Balram Jafar
Jafar.
Patti Mawa
Patti.
and Guru Deluxe Mix and Barbati Kada Masala.
These are locally circulated, all these things. So from 2008 onwards and up to 2000 January.
Government has not banned completely.
No, actually, excise goods under section 3A, this is excise
Not banned.
not banned.
Separate.
Separated it.
Limited.
So
Many states have banned.
from January 2011, I stopped its production. Due to my ill health, I could not continue the factory. So I gave the intimation.
That's a good decision you took.
I stopped the production, I intimated, and department came to my factory and said, seal my machines. Machines physically verified the stocks and everything. That is the route that is there. I closed my business from January 2011 onwards.
In health because of this consumption?
No, nothing. That is some other ailments. So during this period, I was also shifted to Kanpur for my medical treatment. On 22nd January 2011, the DGCI person,
That's
Director
a hub
General
for Pan masala.
Pan Masala.
There's a Kanpur is a city which is a hub for Pan masala.
Pan Masala. So for my treatment, I went there. So in my absence, on intelligence gathered by the department authority, they conducted a joint investigation and in my premises and factory premises as well. No incriminating documents were found. And similarly, on another village at Donga Dahani, in a remote village, there is a clandestine, as per this allegation, clandestine manufacturing selling the same product. So they go there and they seal. And that was the, as per this allegation, that was run by one of his relatives. Though I have no knowledge, because I was in the medical treatment, I was busy with that. During this period, he is duplicating my product without my permission or my knowledge. And that was being red-handed there. And evidence was taken, statement was also under section 14 was taken from the people are available there. And thereafter, the so-called was prepared by the DGCI. And at the page number 47, the 47, paragraph 2.11. The so-called notice, I am reading, in course of search in the premises of the factory of Mrs. Sudarshan product at Burunthi, Sri Ramesh Chandra Swami, supervisor of factory, was present at the time of visit. In the factory, though plenty of raw material, packing materials, packing pan masala was found lying on the floor, no incriminating document was found from the said premises. However, it was noticed that the investigator officer that the packing machine has been sealed with effect from 1st of February 2011. Few statutory records, RG1 registered, PLA books, bill books were found and the same were seized by the said officers under proper Panchanama dated 22nd February 2011, drawn before the independent witness and duly signed by supervisors. No incriminating documents available against me. when they searched the other place, the Ganga place in the village, remote village, where clandestine manufacture going on, the person who is related to the clandestine manufacture was there. And he has stated in his statement that he has committed this without proper registration and now has not paid the duty. He is admitted.
You are not assigned a grant,
Yes, I know it.
your trademark or
No.
whatever the.
No, I have never given, but he has procured from my supplier, from where I am getting, he has procured in my name, and they have in the inside they are doing all these things. But I have no knowledge because I am out of station. So during this period, he has admitted his guilty that I have started this unit, I have not taken the registration, I have not paid the duty, but I will pay the duty. He is admitted in his written statement. I can. In page number.
There is no technical if in this case.
Yes, page number 143. He has admitted his guilty.
In this case, your lordship, the departmental first in this case, when the case was occurred, the department dropped the proceeding, then department went to the appeal to the SESTAC. In SESTAC, both all they appear and it was remanded back to the AO, the adjudicating authority. The adjudicating authority on 9/2/2024, after giving sufficient opportunity to them, but nobody appeared in that, nobody appeared, your lordship. After that, they on telephonic, they received this original order of this ex parte order, and now they are before this honorable court, your lordship. After this getting SESTAC's order, they were appearing on this. Yes, SESTAC they have appeared. Now, yeah, in this case, 3 opportunities were given to them.
In this case, actually, I have transferred from this, where I was staying there in Trinas Nagar.
This is the clear written
Actually, contact number was there. But in contact number, nobody has. Actually, notice was not served on them due to change of the residential situation. Yes.
Yeah, 78 page number.
Yes.
The place of your current place.
Actually, he is not disclosed.
Or they have sent it to old address.
Oh, here the department said in the old address, and that was a tembe. Yes. So,
After, you know.
but telephone contact number was there.
Because they do not have the information. You should have. After, you know.
Yes. Actually, that email address also the councillors could not be contacted. So during this period, when they came to know, the SSC came to know through telephonic message, then he started in.
What steps took against the lawyer?
Actually, he has not taken any step against the lawyer.
What?
The SSC has not taken any steps. After receipt of this order, he has become.
So page number 303, after getting a telephonic information from the department, he went to the department and received the order in original on 8/4/2025.
Order.
Yeah. Your lordship, he may file an appeal. He may file.
Recorded.
Hmm.
Sorry, the assessing officer has deliberately recorded. That's after the contact was what is done. Notices were sent to post as well as. And all came back with the.
Not like this, your lordship.
So they could not. Then they say the personal service was also affected.
Correct.
But
No.
that shows that he's there. So one thing that involved is that he was not. The only thing is the lawyer was refused to look at this. The email address of the lawyer was there. His notice was given to that email. The lawyer did not respond. That my brother is also correct. When you can contact him, that is whatever is passed, very your phone number. Then why you did not call him that we have so notice this notices comes.
When it came back, notices and intimation after remand, it came back. You should have contacted the.
No, lordship, after on.
After the order is passed, that telephone communication.
Telephone number is there, but they are not.
You communicated, now I have already passed the order.
No, lordship, after giving so much of opportunity, we tried our level best.
Not get it, what is coming.
Lordship.
You were attempting, no doubt about
Yes.
it. By post, by sending a person affecting service, even an email service of a lawyer, email address, everything you did. But one bottom line of the story is that you had his phone telephone number. If you can contact him over the telephone after passing the order, you could have contacted him before passing the order, communicating, look, this is the date, I am fixing, you come, otherwise, why you did not?
No, lordship, what happened after the recovery notice was went, this recovery notice, he has written a letter to us to serve a copy. But somehow
How could he get?
on 25/3/2005.
How could he get? What is the mode of service?
By telecommunication from the department to the SS.
No, your lordship, yes, at page number 305, a notice was issued for outstanding demand on 25/3/2025. On it's a municipal tax assessment, this Premnagar, Berhampur.
Which address it was sent?
The address to which intimations were sent? Or any other?
Other address, your lordship.
How,
It's new address.
how could you?
No, how could you, how you got that new address?
It's on someone and this is a different address, but
How could you get it? If you had the different address, the notice would have been sent to that different address.
the lordship, now the infrastructure has been improved by
So,
the.
at the time of impression also, you had the same infrastructure.
And definitely, the lordship, that might be having taken care of. And page number 287, your lordship, you can see, we have taken a lot of initiative.
Course, probably either you are.
I agreed,
Avoiding.
No, lordship, I'm not avoiding.
But you know the difficulties. We are on one aspect. If their person is correct, that department has called him over the telephone, saying that now this order has been passed, there is a demand, you get the bill. So that means the department has a phone number.
Yes.
If the department has a phone number, and when the assessing officer found all these attempts of services is a futile exercise, they could have contacted you over the telephone. But now you are avoiding the service, now I am calling you, you are here, I am fixing that date, I can understand. Second issue. If the department has a new address and can serve a recovery notice of the demand for this, when the department could have served the notice on the new address as well, fixing the date, could have,
I have to verify lots.
Verify means
Whether.
in both the situations, if their version is correct, then also you are wrong. If your version is correct, then also you are wrong.
My
In
lord,
both ways
in
you are
page
wrong.
number 305, you see this that letter is given to the page number 305, that is clear.
That is
I lost.
Yes, please.
They say that it has been sealed by the department. And so
Yes.
it's not done. It has not done. If somebody is producing a spurious material and he admits that I have been producing the spurious material, why he should be?
I lost.
It's an infringement of the trademark.
Yes.
Infringement of a copyright. Both ways. He could have proceeded. I do not know why he has not proceeded.
Actually, sir, he's sick, he's not able to go. Then actually he is unable to move also, this person. When he came to file this petition, he was unable to stay in the file for signing before the registry. Yes, my lord.
You give me a. It's a date. You will be fixing the date in the order.
Yes,
We don't communicate to the.
yes,
Order will be uploaded to download it.
yes.
We'll give you a reasonable time of.
Yes, yes, my lord. No problem. My lord, during meantime, they have the recovery notice has been issued, not take any course in access.
Recovery is the fallout of this order.
Yes.
If this order is recalled, then
Yes,
what
ma'am.
will remain a recovery?
Oh, yes, my lord. That is. Yes, ma'am. Yes. Yes, ma'am. Yes, ma'am. Yes.
Yes.
Your lordship, make
Item 16.
previous case, your lordship. Direct operation, your lordship. For operation of the petitioner to produce the evidence, because there is a specific period of 2 months as per the provision. The refund application is to be disposed of. So let me cooperate. Your lordship.
Yes, call.
Item 16.
May I please, Lord? Now, this petitioner was, while working as constable, Havildar,
Working as
Havildar police,
all the.
Havildar, he was deputed to the RTO, face the criminal, face the vigilance proceeding. Thereafter, he has been punished by the vigilance court. That according to that vigilance court judgment, for 1 year imprisonment, he has been lost his service. Thereafter, he has been acquitted by the Honorable High Court due to without there is no evidence against him. So fully acquitted. Thereafter, he paid for his entitlement and salary and back wages which he reinstatement, but he has reinstatement given, but back wages not given. So I have come to
Sure that it is
It
imperative that the back wages had to be given, or it is a discretion of the judge.
My lord, the petitioner, after
I am
his,
asking you, sir,
my
whether the back wages is a inchoate or a statutory right.
lord, that is the
Admittedly, you.
Rule
did not work-
91.
You did not work for such period.
my lord,
You did not work for such period.
consider.
Agree that the back wages is the statutory right. That the moment the reinstatement is not there is no other option but to grant the back wages. Or if it is a discretionary right, then if a discretion is exercised, then why?
Running, rule 91,
Of
sub-rule 2 and sub-rule 4
what?
of this Orissa Service Code is supporting this case matter.
What? Yes.
Because that I have been already
Rule, just show us the rule. Rule
Rule 91
91 of the Odisha Service
Service
Code.
Code. 91 sub-rule 2. 91 sub-rule 2, my lord.
Yes, sir.
Where such competent authority holds that government servant has been fully exonerated. In the case of suspension that it was wholly unjustified, the government servant shall be given the full pay to which he would have been entitled had he not been dismissed, removed, compulsory retired, or suspended, as may be, together with any allowances of which he was in receipt to his dismissal, removal, or suspension. Another 4, madam. In case of failing under clause 2, in of absence.
Why you are not reading 3? Why you are skipping 3, sir? Please.
C. In the case of dismissal, removal, or compulsory retirement, when the government servant who is not competent, completely exempted
Now,
of the
this
charges.
word- What is the meaning of this word completely exonerated?
Completely exempt would do charges against me. I will completely exempt.
How?
My lord.
What is the meaning of this expression? Completely exonerated.
The allegation, whatever the allegation against me or department
There is a-
proceeding,
there-
department
I
proceeding.
I can understand the word that if he is exonerated, the position would have been different. When an adjective is used prior to it, or something is prefixed, then it must carry some meaning. When it says completely exonerated. So what is the meaning to be given to the words completely exonerated?
All the charges against me, if I have been completely exempted from the same.
What is the meaning of this completely?
Completely from all charges. From all charges means both the departmentally and any criminal case also. I have been if you are completely it is completely exempted, then I will become.
Have you examined?
Madam?
Have you examined?
Madam?
Have you examined
Madam.
the connotation of completely exonerated?
That is according to my annexure. In department proceeding, I have been completely exempted also. Madam. The annexure 4. Department proceeding. And what charges against me, I have been completely.
Have you read certain judgments of the Supreme Court? Now, M.Paul Anthony is the first judgment which says that it will have an impact. Then a subsequent judgment of a GM10 that has come. They propagate a theory of honorable acquittal. The mere acquittal will not do. There should be an honorable acquittal. If it is an honorable acquittal, then only in that case, so far as it will impact the disciplinary proceeding or decision. Now here the word is used as completely exonerated. Now the only thing is that what should be the meaning given to it? Have you worked on a brief on this aspect? What is the latest decision of the Supreme Court?
Well, I have also gone there. That government also lawsuit judgment passed in W also in similar position matter. I have gone through this. My lord, in this case, last line of that judgment, then
Where is that? Where can
running page 21. running page 21, the judgment of Honorable High Court, madam, in my case,
What?
running page 21. Running page 21, last six line, and the
Page 21 is part of your criminal appeal order.
I am asking which judgment you are referring.
judgment, last six judgment also very clearly.
Oh, I am. No, no, which judgment you are referring? Page 21.
83 also.
What is that judgment?
Judgment, lordship judgment.
Yes. Yes, what? Paragraph?
Paragraph 2.4, madam. Paragraph
Running
2.4.
page?
Page 5.
Yes.
Aggravated by judgment and order of conviction and appeal bearing so.
Oh, that is the difference. Show me that where the complete exoneration has been described or defined. Show us. From this judgment, show us.
That bill Farage also cover the same minor.
I am simply asking you, sir, where is the decision which is taken on that? No, sir, this is the meat. The paragraph 7.6, there was a staff. I would say the staff distinction has been made.
Madam.
In this judgment, which you will have to show that what will come within the purview of each. Please read paragraph 7.6.
7.6.
What I said is that distinction that we have noticed in paragraph 7.6.
Madam. In the present matter has already been settled that judgment in the criminal appeal clearly reveals that the applicant advocate of all charges unless you merit and matter for application of details of evidence available on record. It is not a case of acquittal on account of.
This is where the distinction lies.
Madam.
We'll have to then satisfy.
Madam, that is also that judgment of the Honorable High Court. Of
That
the
is what
criminal
I'm
appeal.
saying. You have to say if it is a paucity of an evidence is one thing. And then on merit, every evidence has been scrutinized and then say that no, it does not constitute an offense is one. That was a case of the first nature. Here, they could not prove. If they could not prove, then it comes under the second part.
Madam.
Then you are not entitled.
In this aspect, I am submitting
You are
that.
relying on this judgment, but this judgment is distinguished on fact.
It is squarely applicable. I have gone through judgment, but I'm not able to satisfy lordship. So I have gone through the lordship judgment and I have gone through the judgment of Honorable High Court in criminal appeal. I have also gone through the department charges. In department charges, I have also been all the charges from have been acquitted from the department proceeding. Also in the criminal proceeding before the Honorable High Court, the department has gone all through the evidence and lastly has also stated that there is no.
Look at the portion of the order where the High Court says that there was a lack of an evidence.
Madam, that is it. That is also.
Then you come under the second category of our 7.6.
Madam.
If it is the second category, then 91, 2 or 3 does not apply.
And I am fully acquitted in this criminal appeal, my lord.
Completely exonerated.
Completely. Sir? And because
Probably I am unable to calculate what is passing in my mind. Please, I am requesting you to read this judgment again.
Madam.
And read the judgment which has been relied upon.
Madam.
And in addition to that, I would be requesting you to read the judgment of GM TAC. And the recent judgment, my brother just reminded me of Justice Vishwanathan. What is the meaning of the word honorable acquittal and akin to a completely exoneration?
Then so that I have prepared.
And then come.
Madam.
Mere acquittal does not mean that you are completely exonerated.
No, I have, according to that judgment, I am satisfied. Thank you for fix her.
Mere acquittal will not do.
You are not served copy.
No, the copy has not been served.
Oh, unnecessarily invested so much of time.
Next week.
Give them a 2 weeks time. Let us. Service.
Item forward to item 51. Already my lord filed.
Yes, it's fine.
Item number 34, fixed for 2 p.m.
Specifically, Arjun, right? Clearly, specifically, Arjun, I get that. Since a virus has been killed, the available was to address your lordship. I was talking to him also. Today, his mother's father ceremony is there. He is not there. Can it be some other? The mother's, Sunday mother's.
Let us begin. You have told me that we fix the matter. We would not have fixed the matter.
That time I didn't know that.
What a time.
Matter was hard.
I don't.
It was reserved for judgment release. And I am not for the today occasion. Today's
We never
occasion.
heard the matter.
Madam.
We never heard the matter.
Yes, no.
So we don't know what has happened earlier. This is a personal thing. What can we do?
They have to
Fix up it there and only.
Yeah, after tomorrow is not possible.
as you not but on the same date, possible.
This week is not possible because there are other matters who are waiting for their rights. So we can fix this matter in the next week. Tell me you talk to the next week, what date is convenient to him?
Yes.
We'll fix the matter on the.
Yes, last chance.
My language, last chance.
Thank you, sir.
It's just passing law.
My friend is.
We are just.
Madam.
Confirm the date. Fix that date.
May I call the register? Case admission item number 17.
Other side, there is no other side.
State.
State.
Now.
Your lordship, my lord will get the matter.
whether an appeal lies.
No, my lord, your appeal is not lies. Because one person is.
Oh, this is relating to
the appointment of the, to the
service.
match.
Two persons, including the petitioner, they were acquitted in the criminal case. One person being a regular employee was reinstated in service, whereas petitioner, the temporary employee, was not reinstated. That's have already seen the judgments. But still, your lordship directed me to impress upon the authorities to find out some ways. I have initiated a discussion. If your lordship grant 1 week time, I'll just try to.
Why is he valid second time? Why is he that?
He's taking initiative.
My
The law is well known.
My lord.
The law is well known. So let us see if something can be.
Later in
Next week. Next Wednesday.
Yes, ma'am.
Wait, please, five.
29, you said that.
We talk about the list.
I wanted to know from him, from 18 to 21st, some cases are there in the Supreme Court, that's why he said that possibly I cannot reach. Today is Friday, sir. CPs. 29 teaching it.
Can you not request him that the whole of the week he will not be here?
Monday to Thursday he is not here. That's what he said. From Monday to, some cases have been fixed in the Honorable Supreme.
Can we fix it on 22nd?
22nd, 21st, till 21st he is not there. So
22nd can we fix?
No. 2 p.m.
So, 2 p.m. Say issue Friday.
Then 26th.
25th.
25th.
25th. Yes, call the.
Item number 18.
18.
May it please your lordship. Your lordship, I'm appearing on behalf of the respondent number 5. Your lordship, the mother of the conducting counsel passed away. So we pray for 2 weeks' time.
Which was the petitioner? Appellant?
The state has preferred an appeal and
Yes, we preferred one appeal, another appeal.
The mother of the.
Oh, yes, I got that information.
What do you want, madam?
Your lordship, we pray for 2 weeks' time.
2 weeks.
Item number 19.
On behalf of Mr. Vinit Pai, in the conducting counsel for this bill. And Mr. Saima was present before this court prior to the lunch. Suddenly, he suffered some discomfort. And tension.
Yes.
That is use for the widow. This is employed. All these matters were settled by the Honorable Court, single bench. They take all these matters into consideration, area salary, everything. They made a lump sum amount of factor there. Taken that account.
1 year after.
Next week.
Item 20.
Okay.
Right, please, ma'am. My lords, that matter where my lords, yes, arranging the refacement of my loan. But the bank had sanctioned.
Sarfasi.
Your lordship had asked me to check. I got the judgment of the lordship, authored by my Lord Justice Raman in the alternative remedies taxation. Nothing specific. I got the other one. No, this is the against. No, not surface. I could not. No, this is an income tax where your lordships have entered. No, since an alternative remedy is there, you should go there.
That is a different, that's why we are talking about, you are,
Surfacey.
you have.
Exactly on
You have
surfacey.
filed a repetition
Man.
to quash the notice issued under the security interest enforcement rules.
Man.
That means after section 13(4) steps have been taken.
Man.
Correct? So in that event, section 17 is the remedy, you can go there.
Section
Go
7,
there.
I have come with a prayer for rephrasement of prayer number 2, man. Your Lordship may kindly bear with me. If your Lordship kindly bears with me, man, I'll try to demonstrate before your Lordship, man, that this is a case where the conduct of the bank, man, would invite your Lordship's interference here. Your Lordship will see.
No, sir.
If your Lordship kindly
Law
bears
is very clear in this.
man, I'm not on that part of the law. Man. I'm on the conduct of the bank. Man, I'm purely
Special act, when the special act is.
man, I'm purely arguing. I bow down. Man. I'm not joining issues with your Lordship. Lordship may kindly just give me some time.
A third party, you don't have to deposit.
No, I'm the loanee. I'm the loanee. I'm the owner of the hotel. I'll just Lordship may kindly bear with me. I'll just place the facts for my satisfaction. Not for my side. Let me place the facts. I'll be arguing estoppel before your Lordship. I'm not arguing anything else. Not neither ulterior remedy, minus nothing else. I'm only arguing minus the conduct of the bank. Minus would invite your Lordship interference on the ground of estoppel. That's all. The loan sanctioned amount was 4 crores 37 lakhs. Now, the disbursement was only 2.88 lakhs. They did not disburse the entire amount, even though
Lakhs or crore?
2.88 crores. 2.88
Really
crores.
surprised that.
I am sorry.
How it comes under surpassing. Yes.
These are big figures for me. 437 lakhs was the sanctioned loan. 288 lakhs were sanctioned.
Let us see, just above half.
Just above half. My hotel cost me, project, I built up the hotel. The hotel has cost me 778 crores. Lakhs. And lakhs. So I have borrowed from other sources and all. Now your Lordship may kindly turn to page 37. I have paid them installment EMI for 1 whole year. And your Lordship will see the catch there, page 37. Repayment. Just before that, the entire loan, this is calculation based on the entire amount, 4.37 crores. And I have been charged, EMI for 1 year. I have paid on 4.37 crores. I have not been disbursed that amount, but yet I have been charged on that amount and I've paid them for 1 year. That is almost 1 crore and 5 lakhs I've already repaid to the bank. Then, the OTS, the COVID period came, so everybody, the whole world was in a quandary. So, I was no exception to that. And I also had difficulties, Now, they want to auction my entire hotel, and I have offered them in the OTS 2.25 crores I have offered. After having paid them 1.05 crores, I have offered them 2.5 crores in OTS proposal. They are hell-bent, my lord, on auctioning my entire property of 7.5 crores, more than 7.5 crores, my lord, for a sum of 2.88 crores, not having disbursed and having charged me, my lord, at the rate of the original sanctioned amount, which they have not sanctioned. So I have continued paying them my lord's part of the bargain. I have held my part of the bargain, but for the interruption of the COVID. Since the COVID interrupted my lord, and they did not also disburse the full amount. So I had to borrow my lord from other sources, hand loan and other sources, and complete my hotel. So now I am praying, I'm arguing for your Lordship that I have suitably altered my position to my detriment. Having, my lords, this much of money, because I could have as well paid them much less. 2.88 crores would not invite a installment of.
Did you offer them under section 13(3)(a)?
3A was,
When 13(2) notice was given to you?
my lords, we have been constantly, my lords.
These
No.
things within 60 days.
Yes, 13(3)(a). Let you-
Or 2(a), maybe wrong. Alpha-C, actually.
13(3)(a) talks of.
Maybe 2(a). Yes, 3(a), I was correct. This is introduced subsequently. Are you holding the back?
I am holding 24.
This amendment was brought way back in 2004.
I came to the High Court as against that. I came to the High Court straight away. And the High Court said you deposit 33 lakhs to the bank, they will consider your OTS. Honorable single judge. So I went with 33 lakhs. They did not receive my money. And then, my lords, they moved ahead. Even despite the High Court's order, they did not. I went with the draft. Draft was with me. I went with the draft several times. They did not.
Why did you not complain to the High Court?
My lords, then thereafter they moved ahead, and thereafter again I came to the High Court. The High Court said you deposit 1 crore. That, my lords, was a backbreaking amount for me as a initial deposit, because there was no guarantee that they will sanction my OTS. Now I am before your lordship, my lord, only for this. That my lord, the loan may be refaced. This is not something that I can urge, because there the scope is extremely limited. Your lordship knows it's a my lord.
For the bank.
I am for the bank.
My learned friend is for
My
the-
lord, in this
2.5
case, my
crores is
lord, this is the fourth
not a bad
petition before your lordship. That your lordship kindly have a glance. The order passed by the senior
Yes, I
judge, my lord. That this is the order passed on 18/6/2025. That it. The fourth paragraph, considering the submission made ongoing through the amendments made in this writ petition, further the considering the financial difficulties faced by the petitioner and also his interest in continuing the business, the petitioner is directed to pay rupees 1 crore out of total outstanding amount, which shall be payable by 25/6/2025, and the rest amount shall be paid on or before 29th August 2025. If the petitioner fails to abide by the above terms and conditions, the bank is free to take legal action in accordance with law. They have not complied the orders of this honorable court. They are filing earlier also 3 writ petition before this honorable court to drag the sufficient proceeding. The account has declared as NPA on 29/10/2022. Thereafter, in the year 2023, he filed 2 writ petition, and he did not pay any single amount to the bank. Now the present situation is that 13(4) notice has already been issued in 22/11/2022, my lord. So now in the earlier writ petition, this is the intimation to sell. This is a part of the sufficient proceeding, my lord. This is not maintainable. If any dispute arises, that can be decided by the honorable learned DRT under section 17(1). That is my prayer.
They're stonewalling all my efforts for
That is my prayer.
OTS settlement. And now
OTS
they want to
OTS has already been rejected.
paid my lord, having
The
only
problem-
disbursed,
the property value is more than.
You can appreciate your anguish and agony,
The whole thing is-
sentiments, but the law has to be respected.
No, it's
first.
law. I bow down before the law.
And
I also
that
can't.
event, the difficulty is because I'm stuck by my own judgment.
No, there's the,
I'm stuck by my own judgment where I have categorically held.
I can only,
Which arise from a surplusy.
No.
In that event, the remedy is available under section 17 of the said act. If one person is agree, then he can go.
I would only.
You had actually the three opportunities. You lost all the three opportunities. When Sub 32 notice was given, you could have made an objection under section 33A, and then it is obligatory on their part to dispose of within 60 days.
Yes.
If they do not, then there are judgments which says that they cannot proceed. Keeping that objection pending, they cannot proceed for 13.4. So we would have interfered in that. You did not avail 13.3A. Now 13.4, you could have come and assailed 13.4 at that stage when a notice was given. You did not. Now when they wanted to take steps for now physical possession and the auction, under the security enforcement, the rules, now section 14, they must have also approached for taking over. You could have challenged section 14 action as well.
Well, I'm also not on the niceties of the procedure. I'm not on.
Now section 17
that I'm not
carrying
arguing
it
for
to
your
place.
lordship.
You are a borrower.
I'm only
You have
arguing,
to
but I'm only arguing,
know what is the hurdle.
I'm only pleading estoppel. I'm only pleading estoppel before your lordship, my lords.
Outstanding.
And my lords, lordship, I kindly appreciate the iniquity, my lords. You
What
don't
can be
disperse
done?
the entire
What
loan.
can be done?
It is not as if that they have disbursed the entire loan and I'm running away not
I
paying.
absolutely appreciate that, but that is what I'm saying, that in the writ jurisdiction of bar, I think the London single judge has exceeded the jurisdiction.
And that is also.
I was thinking the bank to come. So the bank has accepted it.
The entire
That is the
property.
redemption is available on the
And
part
my lord,
of
they have
petitioner under section
they
33.
were
For that reason only,
having
if
charged
he is agreed to pay and is saying before this honorable
No,
court that
I would also have an
The
alternate
difficulty
solution.
is that the way he has placed the case, if you have charged the interest in respect of the whole amount, which you did not disperse, then this charging was against the RBI guidelines.
No, that is
And if any surplus amount which you have accepted, those have to be adjusted against the principles, not only in respect of interest.
let that
This
calculation.
is what is there. Don't get enlightened.
No, I'm not.
Still my objection is still there.
I'm
It is
already.
only to him. Don't get
No,
enlightened.
I'm obliged, Manoj. I'm obliged. I bow down, Manoj, but whatever falls
The
from you.
difficulty is the forum.
Man.
The forum is DRT section 70.
So, yes. I can only argue estoppel at this
But the
stage.
only thing is that we are reminding them that what you are doing is not correct.
So they made.
Can you charge an interest
This is the
on a principal which you never disburse? Then we.
the entire Manoj,
that is not
my
the-
bank statement is before your
When you
lordship.
did not disburse the whole amount, can you charge the interest for whole amount?
No, Manoj.
This is the statement of the bank, Manoj, testimony.
Not that.
That will be
cannot be done.
scrutinized by the DRT. Don't worry.
Yes.
I would only need your lordship's one observation, only one observation. I'm
Only
going
observation that the rate is not maintainable.
that, Manoj, and
An
all.
observation.
No, one more lordships have been.
Mr. Palit,
I'm only.
tell me that I am wrong. I am ready to correct myself, but I am stuck by my own judgment.
I'm only Manoj. I bow down to your lordship. I'm only Manoj. Your lordship has gone thus far, Manoj, so far.
After Madia chemicals, after
Manoj,
transcores of the Supreme
That is
Court,
that's the reason. That's the reason, Manoj. I never started off, Manoj. I only started off by saying that I'm only arguing estoppel. Manoj, one observation from your lordship will go a long way to Manoj, to mitigate this issue, Manoj. One observation that the DRT may also consider the question of readjustment. That is the only observation. Only observation at this. No, it will just, it might just end up saving my unit.
Prerogative of the bank. OTS is the prerogative.
Manoj,
of the
at
bank.
this stage, at this rate, Manoj,
What
the
can
bank
be
will have
done?
blood on their hands, Manoj. At this, it's a financial mayhem, Manoj. At this rate,
This mayhem
it's a financial
is
mayhem. They have
invited by
blood on their
whom?
hands, Manoj.
This is caused by whom?
If
Invited by whom?
Manoj, a hotel, Manoj, will be sold off for a lark, Manoj.
There is
I'm okay.
now the Supreme Court has also recently said, even if
They're bound to reform.
before the sale is complete, before
Manoj,
the
even
sale is
after the sale
complete,
is
the sale
complete,
certificate is issued.
Manoj, that
If they do it through a private contract, there are judgments that how they do it with the private contract.
Manoj. So I was only one line observation would Manoj just might mitigate this.
Go and liquidate and go on fighting.
It might save a family in distress. That is my only beseeching, Manoj. I'm only praying for your lordship. It might just save a family.
You pay off the dues and thereafter you go on.
Manoj, I am ready
There is no
without
difficulty. You can get the money back. Everything can be done. There is no difficulty. But
Manoj, I am ready
discharge your
without. I offered 2.5 crores, Manoj. I'm a embattled man, Malad. I'm thoroughly financially embattled, Malad. I offered them 2.5 crores. In my present situation, I can only manage pray. I leave it to your lordship's good conscience, Malad. I can only pray for some Malad's mercy. Mediation. If your lordships are sending matters to mediation, your lordships are also sending matters to mediation.
Actions in the I fully endorse.
Every day is coming on the list, Manoj.
I fully endorse.
Tens of hundreds of matters. So, lordship, kindly refer us to the mediation, Manoj.
We need to say no. We know how to make it yes.
Lordship, send us to mediation, Manoj. I'll take my chance.
Till date, they have not understood that the Mediation Act has already been passed by the Parliament.
Yes.
Only thing is that it has not been given effect to now. The day when it is given effect to, they have to.
I can only pray the lordship, refer it to mediation. I'll take my chance. We can have an adjustment.
You could have, of course, the ombudsman as
That's
Regard auction scheduled to be held on 14/8/2025.
I don't know, the auction is my entire property, my livelihood, and you're sticking to it. My whole livelihood, my family will be uprooted. And can I only pray, Manoj?
Go there.
Lordship's observation that I might approach the ombudsman on the mediation.
Why we are not a advisory jurisdiction.
Manoj.
No. I was saying now whether you have lost your right to go to ombudsman. We are not saying anything. That there must be some right. But now you
So I can go to ombudsman, Manoj. There won't be any delay, but possibly not now, but the delay would hit me here. In this forum, I'll be hit by the delay. That's the problem.
Go to yeah.
Lordship, any observation from your lordship, Manoj, would at least save the family. I leave it to your lordship. I can only urge Manoj on this much.
Difficulty is the parties has to agree for mediation. Because the way
Let me learn
he
it.
has, the way
Come back.
he has reacted,
Hmm.
not appropriate, not appropriate.
Let him come back with the
We do not
instructions.
appreciate the manner he has reacted. When the concept of mediation was thrown, that is how we wanted this sensitization amongst the members of the bar also. How to give this, I would say, impetus to the mediation.
Your Lordship, suggestion can be carried by a learned friend, and he can come back to your Lordship.
He has not understood the concept of mediation.
Let him carry your Lordship's suggestion and get back, my Lord.
He is still in a
He's in a mood
adversary
to file
division.
No.
There is a mediation drive throughout the Supreme Court has
Every day,
already said mediation
Many of our matters have also gone
throughout the nation. Sorry, the national.
including financial institutions.
Oh, they are all. I just said that the Mediation Act has not been implemented as a. The day it will be implemented, you will understand.
All matters having elements of settlement, including matters pending under each following category. Commercial dispute cases. Next page. Service matters, criminal, consumer, debt recovery cases. Debt recovery cases, partition cases, everything.
That's why my lord is saying
This
that
is
on
the-
this both parties free,
Hmm.
we can't add. This is the news from Friday.
At least, Manoj, yes. No, this is a case, Manoj, that some calculation. At least I've made out a case for calculation. I leave it to your Lordship's good sense. One liner
No.
might just end up saving the family, man. That was.
Without delving into the nitty-gritty of the impugned order. So whether
That is my
power of delegation
is not available under the statute. Even moreover, my lord, fact also, that letter never says so. I'll read out only two letters now. Kindly have a glance. And the statute thereafter, I'll take
we are
statute.
just thinking of for the purpose of an admission of the appeal.
My, yes. This
For the other side.
statement, state.
If there is no power of delegation, if the statute says that he is the particular person is the authority.
Your lordship kindly come to page 130 of the impugn order. There the honorable single judge has quoted the particular letter which my learned friend is referring to.
Yes.
It is available at page 113.
Yes.
No,
He has quoted the
I have
order. In pursuance of rule 2B of the rules of education.
My lord.
Correct. What?
That is not the circular.
No, thereafter it is there.
Yes. Was have now been pleased to authorize the special secretary, additional secretary,
Yes.
joint secretary working.
That is the authorization.
Director.
That is nothing. That is the power of the director has been authorized.
Such and such to act as a director.
Director, not as a but now
For
sub
dealing
collector.
with the subject covered under the said rules.
Yes.
74 rules.
That is there. That I have not dispute over that.
Oh, just
Sorry.
then.
The order is passed.
Oh, no, please.
Oh, you let me. Your lordship kindly see.
Then
21, rule 21(1).
he's a teaching or non-teaching staff.
Teaching staff.
Teaching staff.
You are a teaching staff.
Fine.
There was an allegation.
Then.
Sexual harassment. Principal didn't take any
Oh,
action.
These are the
Don't go into the merit.
really good.
Now, this is what you are referring. That by an order of the governor, this power is predicated.
My lord. Why the honorable single judge has passed that order? It has been reflected
Can you
as
show me that rule 2B?
2B. There is no dispute.
My lord,
There is no dispute.
That is the Orissa education within the recruitment and condition of certain.
yes. That is at page, my lord.
Because of the staff
976.
rules 74.
Yes. That is the only point. I will type them, the position of law.
No, that is available at page
976 please.
Yes. Yes.
The power to suspend is there at
Just minutes, sir.
9.
2B.
2B is the director.
Right.
Director means
Let me
Director
please-
Higher Education Orissa with respect
Yes,
to
I understand, because they were referring to section 2.
B.
This
Yes, sir.
rule 2B.
My-
Is that right?
Director means
Normally, every statute or a rules contain the definition
Yes, ma'am.
provisions in rule 2 or section 2.
yes,
That's what
yes.
always. Always.
Yes, I got it. I read it.
Yes, sir.
My
Now,
Now-
where is the power for the
Suspense.
issuance of the suspension order?
rule 21.
That's
the
what I
same
told. That is at
Page 992.
992.
Page 20, rule 21. ma'am.
Discipline officer. The director, the impose and
The direct
without discussion, people and when the director is not created and declared.
shall I read that?
Without going to be.
The employee is defined.
Employees.
Does it include a teaching?
Teaching.
Does it?
It has not been defined, employee.
According to you, it is the managing committee or the governing body who
Who can
not the director.
not the, no, that is not my submission. What happened, my lord, the sub-collector has placed me under suspension, claiming to be the president of the governing body. But
Where is the governing body or a managing?
there is, my lord, there is no governing body. The fact of this case, I am just clarifying.
Oh, there must be a section of the.
Yes, that is
There
there.
must be a provision. Where
Yes,
is that?
governing body is, my lord,
Where?
section 7 of the act.
Rules.
Rules is, there is a management rule also. Corresponding rule is there, 91 rules. First, my lord, kindly see section 7.
Section 7 of what act?
Odisha Education Act. That will get page
133.
Yes,
Section
7.
7 at page 133.
Managing committee or governing body of the educational institution. Every private educational institution shall have a managing committee or a governing body as the case may be, constituted in accordance with rules.
So managing committee or a managing body.
Governing body
Is the
Why private educational institution?
Well, there are two types of institutions. First, the institution established, that is the all the private, they are to honor recognized but not receive aid. Those are receiving aid under the private institution, they are called non-government aided colleges, and those have not received aid from the government, that is called non-government recognized colleges or institutions.
Governing body.
This is my lord, this is a aided institution. This is an aided institution. They are receiving block grant from the government. There is no dispute. That section 3B define what is aided. My lord.
Aspect of schools.
School,
What is
college,
the
and
What is the
college.
composition? What is the composition of the
Managing, yes, ma'am. My lord, kindly
of the
see,
governing body?
that is, there is a rule, madam. Kindly see, my lord, page 681.
Development of the schools. The governing body is college. School.
Yes. My lord, the rule is, there are 3 rules. One is 4 rules. One for upper primary, one for high school, one for junior colleges, and other for private colleges. It is a private college, degree college. So the rule is Odisha Odisha Education Establishment, Recognition and Management of Private College Rule 1991. That will be at page 681. 681. 681. 681. And the composition is Rule 25, which has also undergone an amendment in the meantime. I'm just passing this old
Rule 25.
25 for the governing body for aided colleges. That has been undergone an amendment, small amendment, 25.
So sub-collector is still there.
Sub-collector, no, that is undergone an amendment. No. Sub-collector will be there, no, but in the contingency that is there. Now it has been undergone amendment. Can you see? That is not in the book, man.
Yes.
This 25 plus 6 of that amendment. In the said rule for Rule 25, following rule have been substituted. Total. Plus 6. 25. Notwithstanding anything. Now the pattern has been changed. Here, notwithstanding anything contained in this rule, as soon as the college became an aided college.
No, he is the
opposition.
Appointee of the government will act as a president.
Yes. So collector will nominate a person, 3 persons, they will nominate one. If they fail to, then sub-collector will continue as the president with the members therein. There are who are the member composition that is there under the rule.
Yes.
So with this composition, only a governing body can function. That is why a judgment of this honorable court is there.
Now, what are the powers and duties of the governing body?
Yes, ma'am. That is there in that rule itself.
Which rule?
This 91 rules, madam.
What are the powers?
Madam, kindly see Rule 29. 29 has not undergone any amendment.
Any emergency provision where the president or the chairperson has
No,
the authority?
No, that is why, my lord, this honorable court and division bench judgment, back in 2008, that is the settled law. Now, this has also been decided. Mere nomination of the sub-collector also, he cannot function as the president governing body in absence of a full-fledged governing body approved by the prescribed authority. Kindly see, my lord, para 10 of the judgment. My lord, this is reported of this. Yes, this is judgment, my lord. So, this is the law now holding the field.
So it is a collective decision of
the body.
And it is only the secretary or the president who will communicate that decision of the government.
Oblige, much of it, but that is not. That is not required also. But here in this case, a sub-collector who has even not been nominated because it was stayed in another case in this particular institution, and he has passed the suspension order and he has sought for approval. Though the Rule 21 says, 1974 rule says, prior approval of the director is required for the purpose. He has suspended me and sent it for post-facto approval, which is also not contemplated under the rules. And moreover, my challenge is he has no authority to pass such an order. Para quem não
Okay,
my lord, I'm saying that. In the interregnum, when a governing body is not there, only somebody is functioning as the president of the governing body. That interregnum, how it should be treated, how the things will run, it has been reflected in para 13 of the appeal order. About law, there is no dispute. Power and wishes, but there is no dispute. Only para 13 at page 117. The honorable single judge, relying on another judgment of this honorable court, has come to a conclusion.
That is not a challenge. That is a mistake. Yes, please. I don't think. That is not a
point of view. This is not as simple as you are projecting.
No, it is simple, but
Not-
problem, I have my fixed date.
Now-
And these
now
two
the
judgment,
concept,
I will
because I
say,
have seen that judgment.
those two judgment,
It really opens the two concept of the law.
these two judgments, my lord, I will
It opens the
quite
two
distinguish.
concept of the law.
Yes, we'll see.
The first concept of the law is that whether the legal maximum or the principle of legal fiction can be applied. Because we find that there has been a certain thing which is not really in express words incorporated. Secondly, whether the principle of casus omniscience can also be applied in this case. These are the two principles on which we have to decide. The judgment which he is referred, he has proceeded on that basis that, look, the director cannot be said to be lacking in complete powers or the competence to suspend. What it says is that in the event the managing committee or the governing body declines or neglects to suspend, then in that event, the director can act as a disciplinary authority and he can do it. The logical inference by virtue of the legal fiction was brought by that judgment, saying that why not it will be conceived that if there is no governing body or a managing committee, then in that event, why not that director would also exercise such power? The question of neglect or the question of refusal is being construed in such perspective that if there is a governing body, if there is no governing body, then it says that once the power is given to the director can act. And the definition of the director is that if anybody is nominated by the government or is appointed by the government, then he will come within the definition of a director. Now the question is of a casus omniscience also that comes. That what would be the position of law now after this particular situation? Is a conscious omission or no? We want to hear. This is an interesting question of law. We want to hear. When can be done? The judgments are not so simple.
No, right.
My view is to take a dissenting view.
My lord, it will welcome. But here in the case, my lord, it is not the power of the director is involved in this case. It is the sub-collector power. That is my challenge.
The sub-collector has been appointed by the order of the governor to act as a director or discharge.
No, my lord, that is not the fact. That is a mistake.
We have seen that order of the governor. Then in that event, what?
The sub-collector was not appointed by that rule.
Oh, it's not a question of any rule.
Right.
Let us come with this. When
any date, my lord, fix. I will. Any date, my lord, convenient to
you
my
are not reading on legal fiction and casus omniscience. That is what I'm saying. Tell me when.
Well,
Or 21st. Yes, my lord. Convenient to my lord.
The first?
21st. Obey.
There is no other big matter on to the You come on that proposal. Let us see.
Yes.
Test.
22.
Interesting. Let us see.
Right. Can we at 2 p.m. so that I'll be ready.
No. Let us see whether we can go to the answer. Right.
Sir.
But it may please go loss. The appellant challenges the judgment. Sorry, man. I have to take notice in the meantime because there is private opposite party.
Oh, that
is to this.
Find requisites by tomorrow.
Mine.
Put in the requisites for tomorrow.
So only to private parties. Yes. The appellant challenges the judgment of Honorable Single Judge dated 29/7/2025 Managed Teacher Annex 1, in which the appellate authority order has been confirmed, holding that I being appointed as an Anganwadi worker do not belong to the center area. So the guideline has been violated by appointing me as an Anganwadi worker of Musundi 5 Anganwadi Center. I am taking to your notice to the guidelines at page 21, my first. What guideline says? Who will be eligible to be appointed as Anganwadi worker, my 21, my
Yes.
page, annex 2. Revised guidelines for selection of Anganwadi workers, my lord. This is dated 2/5/2007.
Yes.
First clause 1, only one clause 1. Applications for selection of volunteers to work as Anganwadi workers will be invited for each village or Anganwadi center area from women residing in the said village or Anganwadi center area. This is the guideline. Either she may be in the,
Uniform
of the
guidelines, sir.
uh,
It's a uniform guideline
Everywhere.
everywhere within that village or within that
particular area, my lord. This
And it
appellant
must also contain that if there is no suitable candidate found within that village, adjacent them.
my lord, the appellant made an application being the inhabitant of that village, as well as his
Before
registered
marriage or after marriage?
after marriage, my lord.
Ah.
After marriage. Then, my lord, she was selected, securing 62% mark, 62% mark, and the respondent of 4 secured 43 point some odd marks, my lord. She stood fourth position, my lord. Four. She challenged in the appeal the order of my selection and appointment before the additional district magistrate Sonpur.
On what ground?
The ground that I do not belong to that center area. The
Not even village.
not even he did not raise the question of village. It is admitted I belong to that village.
Not on center village / Anganwadi center area. That means the option is given both.
Yes.
Because the Anganwadi center area may cover 2 villages.
Yes, ma'am.
And therefore it says that it should be like this. A village.
Then
What do you say?
Then, my lord, I was appointed in 2013, my lord. The other 2 persons who were selected, my lord, who I was selected. Serial number who remained in merit list.
Number 2 and 3.
They were not included as party.
They were not included.
Then the additional district magistrate, my lordship, kindly come to the page 32, my lord.
Yes. What it says?
Then I am
Tell
listening.
me.
Say that she was selected violating the guidelines. Unnatural justice. My natural question does not.
Did you submit your residential certificate?
Yes, my. Yes.
Showing that you are within the Anganwadi center area or
Of the village, as well as I was residing in under Anganwadi center area.
who has given that certificate?
Certificate has been given by the Tahsildar Birmaharajpur under Annex 4. You lost your kind.
And this comes within that Anganwadi center area?
Yes, Tahsildar. Page 28, my lord.
That's why the appellate authority disbelieved.
Appellate authority disbelief of a report of that supervisor who says that my father-in-law resides in the Anganwadi, Musundi Anganwadi Center 2 area. Therefore, as it has been observed that my father-in-law was staying and my name has been reflected in the list.
What list?
No, that is the family list, they say.
Where is there any maintenance of a family list?
They say that one list has been maintained.
In the state doesn't, I do not know this concept.
My lord, therefore,
The voter list.
no, not in the voter list. They say that they belong to that family area, the family list, my lord. They say. Yes, my lord, you will also can see. They say that the observer has submitted a report on 14/12/2012 stating that the respondent number 1 is myself is not a resident of Center 5 of the village Musundi. Rather, she is the resident of Center 2 of the village Musundi. She has also submitted a list of persons whose house situated in Center Area 5 of the village Musundi. That is
Do
from.
you have any residential property in this particular action area 2 where you are saying?
Property in my name, my father-in-law's name.
Father-in-law's name is in 5. It's
No, in
outside.
2, mine, in 2.
And this is in relation to 5.
5.
Which is the school.
Correct. So now, do you have any other assets in 5?
No, I have no asset in 5, my lord.
Then where you live? On an open field?
No, I am residing in a rented house.
Did you produce the?
Yes, I produced the.
Produce a rent agreement.
I produced that certificate from my landlord.
Village, whether the rented accommodations are available.
Rented accommodation, yes, my lord, in village rented accommodations are available. Those documents were not taken into consideration. My lord. Then
you filed the rent agreement.
I filed before this honor court that not
before this honor court. Before the appellate court.
The appellate court that the certificate issued by the
Tahsildar.
No, that certificate issued by the ward member and the my landowner.
Landowner, what he says?
Says that she is residing since 2010 in my house after being separated from her father-in-law. And government in her counter.
And your husband?
Husband is cultivator.
So he goes and cultivates.
No, it is within one village, my lord.
Father's property.
It is one village, my lord.
I'm asking people what he cultivates.
Cultivates, my lord, is Delhi weather that goes and get Delhi weather. Then you will also kindly see before my selection.
Is related to you.
Who am I? No, Tahsildar. Then my name has been registered under Musundi 5 mile. That document has not been taken into account by both the courts below.
When?
That was on 2/4/2013. That when this appellant became pregnant for first time, her name was registered in Musundi 5 Anganwadi Center. Annexure 5 mile. It's a document I have given.
And when this application for the Anganwadi.
It was invited in 2012.
Invited when?
This was invited on. I am giving the date. In 2013. 2013. Date is not well.
Contemporaneous time.
Therefore, as these two documents have not been taken into consideration, Annexure 3 and Annexure 4, my lord.
When you are admitted in the Anganwadi Center 5, whatever.
That is on 2/4/2013.
And when the application was invited for
That during that period, my lord.
prior or after?
Prior, my lord. Then, my lord, these two documents have not been taken. My humble submission will be for losses. That as the guideline provides that either she belongs to that Anganwadi area or village, my lord, she is eligible to make the application for the post. I made the application for the said post, my lord. Even if, my lord, for sake of argument, I said that I don't belong to that Anganwadi area, center area. I belong to that village, my lord.
Which village?
Musundi.
And where the Anganwadi Center is set?
Set in Musundi village.
25.
Musundi has
Five Anganwadi centers. Musundi village is a big village. It has 5 Anganwadi centers. That I belong to the same village, my lord. Therefore, that what has been observed by the appellate authority confirmed by the honorable singular, the guideline has not been violated.
Why will be a 5 centers
Yes.
in one village?
It's a big village, my lord. Musundi village is a big village, 5 cities.
What is the geographical
Geographical
area?
area, my lord, I have no knowledge about that. Big village. What I have,
Kilometer or 50 square, not that much.
no, that is my lord, 5 bastis will be there, 5 hamlets will be there. In village, it is Musundi.
There is a separate, Anganwadi center. How many Anganwadi centers?
5 centers.
As a matter of fact, about how many Anganwadi centers are functioning there, I don't have any interest. From the number, it appears that Musundi 5 has got the Anganwadi center. The survey report of the CDPO.
No, yes, I just wanted to know that what is the geographical demarcation?
My lord, I understand.
Because when the village name is one and then 1, 2,
2, 3, 4, 5. Why?
then there must be some demarcation
Man.
on a boundary line.
Of
And
each
one
center.
has to understand that this village
Man.
is name may be one, but village
But-
number 1 is considered. And there is a different system which is prevalent there.
The system is from this house of from this person to house of another person that comes within one Anganwadi center.
That is what I say, the territorial jurisdiction or
That is being followed
boundaries.
everywhere in Odisha.
If the village is divided into a territorial part, then it
Yes.
is an independent village. Maybe the name they do not want to change, but by
But-
giving 1, 2, 3, 4, 5.
Right.
So these are all called the different villages.
Here, my humble submission that village name is one, that as it is a big village, from particular house to another house.
You do not understand what I am saying. The village has to be because there are a particular area which
Yes.
is known since the Vedic era by a particular name. Now, everybody they are obsessed by that particular name. They do
Yeah.
not want to change it. If that being the position, now, since it is too big, cannot come within the village, then for their convenience, they have given a territorial boundaries, keeping the name intact, but by adding 1, 2, 3, 4, 5.
No, here only one revenue.
So each 1, 2, 3, 4, 5 constitute an independent village.
Yes.
May I propose one thing, my lord? Your lordship may call it next week, details I will bring.
My lord, it is one revenue village. I will file that whether it is one revenue village or not, my lord. Within one revenue, they have separated that the area of the center area from one household to another household. That's what I have understood, my lord, from my client.
Why I was proposing that, my lord, because CBPO report, it is reflected here in this, that the petitioner of the appellate.
Please tell me that whether you have really demarcated the village. An independent village has come. Otherwise, it is impossible. That maybe for your convenience, you have divided into this 1, 2, 3, 4. But the village could still be regarded as the one village. And it comes within particularly one as a one unit.
Over there, I can take specific instruction that will be helpful. my lord. Your lordship call it at 19th or 20th, I will give it well.
And you will also make a cup on 21st May. 20th or 21st May.
Yes, come. Understood. To come, we will dispose of it.
My lord, I may be protected unless I will be disengaged. I will be disengaged. I mean service. Direction was given to disengage me and appoint respondent number 4.
Okay, no, respondent number 4 can be appointed. What about the number 2 and 3 who have not approached the court?
My lord,
No. 1 and 2, he's 1.
He's 4.
Oh,
He's 4.
He is for.
1 and 2 relinquished.
okay.
3 belongs to that area. But she was not given, so it's still appealing.
No, appeal is the respondent of 4, my lord. Other 3, 2, 3,
You
my.
are 3 or number 4?
I am number 1.
Number 1.
I am number 1. I was selected. And
No,
I
in the panel which was prepared, you were shown in serial number 1.
I was given appointment.
And serial number 2 and 3?
They did not come forward. Did not come
And
forward to
this
file.
is serial number 4.
4. He filed out.
Then how serial number 4 can be directed?
Now,
to
my lord, what happened?
2 or 3?
Before this, my lord.
2 and 3 also belong to the area.
That area.
There is no adjudication because 2 and 3 are not made parties.
No, my here, my lord, in the before honorable single judge, the honorable single judge asked me to include them as parties. I was included them as parties in the writ petition, my lord.
I will use my office by instructing them not to take any action till 21st.
So, oh, I understood. So he's number 1. So 47 is directed to be appointed. 47 is and I will but what about 2 and 3?
They relinquished.
Secured 51% because he secured 62. So they were not called for the appointment. Relinquished. Where is a letter of relinquishment?
They came before this honorable court appeared and filed affidavit that we will relinquish it.
Who?
Affidavit here.
Oh, they filed. Then it's on. Then we'll take care of it.
They filed.
Oh, I understand. Come. Yes, come on 21st. He has assured that he will exercise his office not to.
Yes, I.
Item 23.
That notice will go to the private party.
Or that let him go to the private. It would take time.
23.
The roster pass an order to that effect unless they may not obey that. Why not they are possible? Because roster file specific.
There will be some.
Unless it is not
adverse comment observation will be against you. That's why we are not saying anything. Let him come with the instruction.
Till then, I will protect.
Yes, he says that he will not.
Item 23.
May I please? No, this is a recomplaint against the order of the Honorable Single Judge. The facts are that I am an elected sarpanch.
You are not a?
I am an elected sarpanch. And no confidence motion was initiated against me. And a notice was issued to me only saying that a requisition is sent. The proposed resolution was not sent. That notice was in Odia, that is Annexure 1 to the writ petition. The English translation I have given in the writ appeal.
This is a requisition by some other members.
1/3 members will propose a resolution, then send it with a requisition to the sub-collector. The sub-collector will fix a date for the special meeting, giving 15 days clear notice. And the requirement is
that accord with the requisition, they have to give their
proposed resolution. Proposed resolution.
So you decided by your person.
I was just recapitulating.
Identical case.
That was not necessary. That was not necessary.
Yes, resolution that
Requisition
in some must be
That is what I was going to add.
Yes, my lord. Your lordship, may kindly see that requisition, that notice under Annexure 1.
What?
That is in Odia. Only says a requisition is sent.
Yes.
And I relied on a decision.
Resolution is not sent.
Yes.
I have held against you.
Paragraph 18.
11.
11. Yes, go to paragraph 15.
Yes, ma'am. We are unable to comprehend the contention of the appellant. The expression copy of the resolution appearing in the aforementioned procedural provision is to be interpreted in a sense that it should be a part of annexure to the notice requisition. In other words, such resolution must be recorded in a separate piece of paper and to accompany along with the notice. The purpose of the resolution having taken in the meeting to be accompanied with a copy of the notice is to be made known to all the members that the meeting would be held, that the discussion shall be made on the agenda or the decision taken by the requisitionist in an earlier meeting pertaining to a no confidence against the serpent. Such procedure is to ensure the fairness, transparency, and the meaningful discussions to be made on the proposed agenda of the resolution, and none of the members should be put on surprise on the date of such meeting. The purpose is laudable as the authority convening the meeting has to ensure not only the strict compliance thereof, but also to secure equal participation of the members for the meaningful discussion on the proposed meeting. There is no prescribed mode as of now that such resolution must be transcribed in the separate sheet, as the interpretation sought to be made by the appellant, if accepted, would frustrate the legislative intent and be opposed to the provisions relating thereto. The court must adopt such interpretation which would further the workability of the provisions than to render such provision odious or redundant. The court must harmonize the different provisions of the statute to make it workable unless the court finds such provision irreconcilable. We don't find any discord between the steps taken by the author in the spirit of the statutory provisions appearing under section 44 of the said act. We have been taken to the requisitions and the copy of resolutions annexed to the writ petition, as well as in application for stay filed before it. We find that the copy of the resolution was attached on the next page and therefore satisfies the conditions enshrined in section 24(2)(a) of the said act. We thus do not find any justification in the stand of the appellant in this regard. So far as the second point asked before.
That is the difference, singularly by the president.
Yes. Here, my lord, I draw your lordship's kind attention to Annexure 1, the notice. If it spells out sending of the resolution.
It will not. It was also a case which does not. It does not. It was simply set a resolution, and what resolution?
The word resolution.
The requisition.
It is only the requisition sent.
Correct.
Yes. And the
requisition indicates that what for they wanted a meeting.
Yes, madam. And in the counter affidavit, in the writ petition, in the counter
is covered by my brother was not there.
Just
I think you can convince my brother to have a dissenting view.
My humble submission. I
am bound by my own judgment.
My humble submission. The language of 24(2)(c) is.
Sir, go through it. I have taken. What can I do?
And
this court and division bench has taken.
Yes, ma'am. My humble submission, this finding, we find that a copy of the resolution was attached on the next page. It is not there. And that in the counter.
But that was a factual matrix. But the proposition of law that it does not require that separately the resolution has to be given. It was said this is not the spirit of this. That is what I.
Not one thing. And in the counter affidavit, what the authorities say that it is not necessary.
They are emboldened by this judgment.
That is the judgment.
Can it come tomorrow so that I can further examine?
That is what I say. You can examine this. And still I tell you, if you can convince me that I am wrong, I am ready to accept. And we'll take a dissent other means.
The no confidence motion was held. Voting was
go through it. Otherwise, we'll go by this.
Otherwise, it will be.
I'm appealing for the appeal part number 3.
Yes.
The service matter, it is not assigned to about 690.
Service matter not assigned.
It is a restoration, no legal. Restoration it is.
Oh, this is a restoration application. So, so dismissed by?
Then Chief Justice and Honorable Justice Mr. Patna.
So that is why it has come before the Chief Justice. At that point of time, the Chief Justice has this determination. Then it has to go according to the roster. This was disposed to. We have to go. Restoration, I was under the impression the Chief. Though this matter was entertained by
Your petitioner paying for
have you
the
served? Have you served or not? Service.
Served.
You are appearing for all?
I am appearing for yes, one, up to 1, 2, and 3.
Rest?
4, 5, the State Pollution Control Board and State Environment Impact Assessment Authority, they have their own. Yeah.
Then you'll have to serve them a copy. On the rest, well, others issue notice, 2 weeks, come back.
Deeply.
Item 27.
Thank you. I have already removed the defeats.
But this is what is this application?
Because of the non-removal of defects that has been dismissed by the ministry.
Donation of delay. What is this application? This is IA 146.
Yes, sir. That is for restoration.
But it says this allow this application and condone the delay caused. Oh, restoration. This
Let me remove the defects also.
You remove the defect, that's why it was dismissed.
Yes, sir.
what should I pass the order, madam? If this prayer is before me, page number 3 of this application, tell me what order. Then allow this application. Now, what should I allow? What should I allow? I do not know what to allow. No? That I've seen. He has asked for a condonation as well, composite. I have seen that. Now, madam, you say that this court may be pleased to allow the application. What allow? How I will allow? Tell me. Then you'll have to write. Please to restore the writ petition to its original file. Please to allow the application. Now, how I will allow, I do not know. There is no prayer. I will simply write it. The application is allowed. What is this? $740 days delay. What you were doing? What you were doing when it was dismissed for default? Yes? No. When it was dismissed for default, writ petition. Recall the order dated 9/5/23.
9/5/23, but order was passed by the Assembly 4 years. After that, before the registered but dismissed. That was
Register, it was dismissed on the ground of removal of the defect. Oh, have you removed the defect? Yes, allowed. It's come. The new status has come. Removal.
Eight. What was the defect?
synopsis was.
It was not filed. Has it been filed?
That is not updated. So that is
No. Hard copy is here.
Yes.
Sure. That's all. Where it is? This one. The index. No.
That is filed separately. It is not there.
I just wanted to know the hard copy is here or not.
When have you filed this synopsis and date cut? Have you filed it?
Yes.
When have you filed? Where is the receipt?
Okay, removal of defects.
Madam, when you filed the synopsis and I do not know, that's a list of dates. In the department, there must be some receipt, there must be something which is given to you.
Removal of defects.
Where have you filed that? In the registry?
I just wanted
Where's
the
that?
receipt for filing.
Register must have given. Otherwise, how could you file? Either it is the defects are removed, there is any written requirement, then it is report stamp reporter. If you want to file any document, then that must be in the registry. So there must be a receipt. Naturally, madam. They don't give receipt.
Removal of the.
Removal.
I failed to understand.
All of defects were not giving any receipt. But before the staff reporter was
What?
was in the file there.
No, just please tell me. I am really surprised with certain procedures. So I will take some decision thereupon. What is the procedure you said?
When a document is filed for the purpose of
They have no
complaints
receipt.
of defect.
They are not receiving.
So that is what we are asking.
I thought the only other.
No. What is the dropping concept? I just wanted to know. He said that dropping in the box.
No, when it was filed, the receipt is given.
It
When a
was
document is filed, the receipt is given.
Sir, dear viewer, document.
And so in the portal it is there.
If the case status,
If
the
case
defect is
status,
removed.
if it defect has been removed, it is noted. So I am.
Case status.
I also.
Which item is this?
47.
Office note?
Case status. Charges for suspension.
So this is for restoration application. Conversion repeats.
In the writ?
Yes, yes. In the rate it is there.
Where is the writ?
Right.
Online defect is going
Not there.
No, if it is online, then no receipt required. Online perhaps is remove the defect for online. Online.
And state and cloud comparison.
Remove it online removal. See,
Where do I get it? I am not getting it.
Oh, we call it the own objection complied.
What is this? This shows.
This will be, I can give here well, the printout also.
Very interesting. Anyhow, we believe this. This is an application for recalling
Yes, Your Lordship. This is, I'm for the ocular and this is a rate of pay, I try to PWD candidate and I was trying to about the combination of the level
64 days.
60 days. 64 days as for PW, as for ocular is a PWD candidate and so in suffering from typhus last
Commissioner for responsibility of company. You are receiving. All the.
No, there are how many respondents?
4 respondents. Three plus 1. State Commission for persons with disability.
This is the number 4 notice has to be.
You are not at the report. It's the.
It's under the Persons with Disabilities Act. 1, 2, 3 I'm not hearing. 4.
4 notices to you.
Yes, notice.
Yes, sir.
One, 93, 50,000.
Item 29.
Remain the period of 41 days as. That one was.
Sir,
This is servant appeal.
how many days?
41 days. 41 days.
41 days. Yes. 41 days is problem.
Private respondent number 1. OUT is respondent number 2, university. Nobody has appeared.
They contested in the trial court.
They are.
They contested in the trial court. Then you have to serve a notice.
Notice has issued by this one. Which has issued this.
Service affected.
Service.
Neither the AD nor delivered, huh?
The tracking report is item delivered.
Delivered. Then it's all.
Personally also served by through post also.
Then allowed. What? Despite service, there is no representation on behalf of the department. Sure.
But
He is allowed to
So
for admission of VCS.
item 30.
How many days did they serve?
6 days, sir.
What is there?
Okay, sir.
Copy, we have not received a copy.
Yes, it has gone by.
WhatsApp, but we are unable to open that file and make a print out. Yesterday only I informed the clerk, sir, but he denied us to give the copy.
What?
Did you?
Clerk.
What?
Yes.
Please.
No, clerk of.
He had sent it.
No, clerk of my learned.
Anyway.
I requested for a copy, but he denied.
Who?
The clerk of my learned senior.
I was surprised when you looked
No,
at
no,
him
no.
and say that when we asked him and he denied.
No, Your Lordship, I told the clerk of my learned senior.
Anyway, physical copy, sir, that was sent to you, my lord. WhatsApp. On Saturday.
6 days, madam.
No problem.
Allow.
May I pray for next week? If possible, my lord.
Yes.
Item note 32. Madam को लगा टाइम रहेगा. 32, sir.
Is it for an adjournment or the other to review?
Right. Item 33.
Is it's a tender matter. That's what has happened here. Opposite party number 2, despite not meeting the essential pre-qualification criteria, his bid was first technically evaluated and then he was adjudged to be the L1 bidder. And that is what I have challenged with your lordships. The lordships may straight have the notice inviting tender which starts at Annexure 1, page 22. Short application for amendment. I'm not pressing that up. I'm not pressing that up. Your lordships may have page 22, Annexure 1. The short matter minutes won't take much. At page 23, your lordships will have a notice inviting tender. Lordships have that notice. Yes. Page 23. The lordship will find the tender issuing authority is NALCO and the date of tender is 5/10/23. Subject is cleaning of overhead water tanks of residential and non-residential buildings and underground reservoir in Nalco Nagar township of CISF colony by mechanical means. That is what the work is, cleaning of overhead tanks, underground reservoirs of clean water tanks. Well, if there is an essential pre-qualification criteria which has been prescribed under the tender. The lordships may straight have page 71. The lordships have page 71. Yes. That's your lordships finds. Subject is the one I just read out to your lordships now. And then it says, agencies intending to participate shall fulfill the following minimum pre-qualification criteria with supporting documents, and they need to fill up Annexure C25 to C27 of the NIT to ensure submission of all documents as per requirement of NALCO. Pre-qualifying criteria. Technical. It says the bidder should have experience of having successfully completed similar work during the last 7 years, ending the last day of the month previous to the one in which NIT are invited, should be either of the following. 3 similar completed stroke partially completed works with each with above criteria having executed value of not less than 8.68 lakhs. Number 2, 2 similar completed works, the value should be 10.85 lakhs each. Or number 3, it can be one work.
But higher value.
Higher value it goes. Your lordships can then have the work experience should be of working directly and possess relevant criteria as per details given under the experience criteria. Your lordships can skip that and can have the definition of similar work, which has been there, has been emboldened. What does similar work mean? This means cleaning of overhead tank stroke underground reservoir by mechanical means. So it's a twofold criteria. One is that the work order which is to be supplied, it has to qualify the definition of similar work. And secondly, it has to meet the value criteria as has been prescribed. If they give 3, they will have to meet. If they give 1, then 17. Now there were a total of 5 bidders. 3 got disqualified. Myself and opposite party number 2, they stood qualified. Now with respect to this pre-qualification criteria, opposite party number 2 has submitted a work order which your lordships will find at Annexure 5. Your lordships have Annexure 5? Yes. Your lordship sees this is a service purchase order. And on the third box, your lordships will find a subject, SUB. Your lordships have that? Yes. It says maintenance of wastewater treatment plant, sewage pump house for the year 2020-2022.
So according to you, the nature of the work is changed. What was not invited in the tender, he has been awarded that.
Yes, ma'am. He is not meeting the essential pre-qualification criteria. The criteria was he should have.
So why you are bothering about it? Now you are concerned with the cleaning of the overhead tank. and the underground reservoir.
Yes.
So you go and do that. Why
No.
I was get transgressing into this domain of the water treatment plant and the other.
No,
Submersible pump or what?
Yes,
Sewage
that's
pump.
sewage pump house. This is a work order which he has submitted with respect to the pre-qualification criteria.
Oh, pre-qualification.
Yes.
That is what you say.
Yes, ma'am. And this has been accepted. That is what is my predicament.
I thought you were saying that he's awarded this contract.
No. My apologies, Malad. I did not, I was unable
Say
to.
that.
Yes, ma'am.
The essential qualifications which are there, he has relied upon this document.
Yes, ma'am. That is precisely what I was trying to convey. Now, this is what has happened. And if the Lordship's knowledge turns to page 236.
So the entire decision has to be scrapped. Who is for Nalco?
I am for Nalco.
Yes, it has to be scrapped because his tender is technically disqualified. Then he will be the single bidder.
No, in fact, Your Lordship, what my learned
He will be a single bidder.
No, in fact, in the meantime, in fact, the work has been awarded to opposite party too, and he is executing the work for more than now 15 months.
But that is subject to.
Yes, subject to outcome, yes.
Yes, ma'am.
So,
There is
so
an
far as
order.
so,
How can you do it if you have defined a similar work? And the similar work means that the cleaning of the overhead tank and the underground reservoir. Does it follow the requirement of the wastewater treatment plant?
Lordship, Lordship,
Does it
part of the same work order?
How?
No, Lordship, may kindly see that page 234, annexure 5, which was placed by me learned.
Yes, you are at that.
Page 237.
Correct.
It's part of the same work order.
No, it's not. I mean,
There were various scope of work given because this work order was also issued by us in a previous contract. So in this, the scope of work,
bill of quality and the, what is this? Bill of quantity and schedule of rate.
Schedule of rates, page in the what was the work assigned to him, the heading may be that, but in the work assigned at which starts at page 237, what we are relying on is page 240, clause 23. This is the similar work which was being done by him under the same in that same contract.
Just it. Where do I get it?
Page 240.
I'm at 240.
240 activity
Serial number
23. Mechanism cleaning of sedimented sludge. Mechanism cleaning of sedimented sludge, and sludge is underground reservoir. So here, mechanism cleaning of sedimented sludge deposited in zero discharge slump oil.
How can you say underground? Sludge, there may be, suppose if there is a low land and there is a water which is filled, the sludge will always be there.
I'm sorry, it is deposited in zero discharge. This sump, I'm sorry, it's a sump. This sump is the underground reservoir. Here it is mentioned, if you're not sure, mechanism cleaning of sedimented sludge deposited in zero discharge sump pit. Sump pit, yes. Yes, and the sump is because this work order was issued by us. And in fact, in this case, after he raised a complaint, we have also examined that and we have also observed that in our report and intimated that. Only after that we have proceeded to award the tender.
What my learned friend is saying is that a zero discharge sump pit is an underground reservoir.
What about the overhead?
The overhead in the pre-qualification,
both.
Limit is monetary limit is also.
Yes, we have
in monetary limit, in fact, we have taken a decision.
Monetary limit also should conform to this work.
Well, at page 236, your lordship.
Have you considered that?
Yes, we
I
have
have seen. I'm at that. The 32 lakhs they have given. I am unable to find out that this was
with respect to that
mechanized cleaning. If you say that it is less than even 1 lakh.
Yes,
no, the total work order value we have considered.
Can you
page 277.
Sir, when you define that particular similar work to meet only the overhead tank and the underground reservoir, and then you have said that the minimum value, either the 2 works, minimum value of this, or 3 works, minimum value of this. When you have identified it, how can you, if they are given a multiple works, say the construction of the road in under work contract, the construction of the road, cleaning of the road, the gardening is to be done, and then also the cleaning of the underground reservoir or the overhead tank. Everything is, say, the club together, and the value comes to 10 lakhs. Will you take the 10 lakhs as a barrier?
No, in fact, in this case, even for the petitioner and for this opposite party, we have considered the value of the entire work order.
Can
Not
you? I am asking, this is what I really find from this. How can you? Because this is what I find that the mechanized cleaning of the sedimented sludge is 57,000.
When you confine your document to say that it covers serial number 23.
Serial 23.
So
That is
23 number is 54,000.
But the entire work order value was higher.
So can you?
Yes.
I'm just asking a very simple question. Can you segregate it?
No, in fact, for this, since for the petition, in fact, in all tenders, what we have also filed that document. Depending on all tenders, what we are doing is we are considering the entire work order value.
Sir,
Even for the
define
petitioner,
similar work.
petitioner also
Please
we are
do not define the similar work. Do not define the tender documents. At the time of floating the tender, that's some kind of a discussion is left to you.
No.
Why, when once you define it, can you define?
Lordship, just give me another thing.
Nothing get you down.
Because the lordship here, in fact, more than 15 months also he is working. And
Maybe illegally, then he is entitled to a compensation because he has been illegally and wrongfully deprived.
Your Lordship's order on 3724 clearly says it is subject to outcome of the writ petition.
NG, without prejudice to this submission, NG projects judgment also Honorable Supreme Court that the PSU should not be put at prejudice, because now if this is quashed at this stage, 15 months we have already executed the work. We have got the work executed. Then it will be the amount to re-tender again. Then it will be prejudice.
What prejudice?
Because that is what the NG project judgment said. Even if there is an arbitrariness.
PSU company has violated a fundamental rights of a citizen. And since this violation was 15 months ago, so PSU company is immune.
No, I'm not.
Immune, cannot be touched at all. This is a law. I have not.
I'm not
come across.
No, I'm not saying that, because the ramification, that is what
The ramification, a person who is a perpetrator of a wrong and wanted to reap the benefit of his wrong, saying that 14 months, and when this order was passed, indicating that this is subject to the result of the writ petition, then you did not challenge that order.
No, in fact, that was also after the work order was issued.
But at that point of time, it has just started.
Yes, the work has started. Yes.
So, because I find 12 months has already elapsed, and you say 15 months means only 3 months they work.
Yes, before that 3 months. Consider the NG project judgment also. In the NG project 2022 Supreme Court, because there Supreme Court has clearly said that even if there is an arbitrariness, then also the court should not interfere and the petitioner will be at liberty to claim damages.
This is what I am talking about.
Yes,
damages.
damages
Why not the court will grant a compensation. I may not interfere with his work, but he is entitled to a compensation.
So for this compensation in the litigation only.
Why not? Can the court shut its eyes?
No.
Why not?
Lordship may grant me and date, I will get back to you.
No.
May I suggest one thing? I will match the price. I am all.
What you will do?
I will.
He has already put all the mechanized, the equipment. He has already rendered 15 years. Only thing is that you were unreasonably deprived.
Yes.
There was some right which was there and we have been deprived.
Yes.
That the compensation is going more. That's all. You can't experience.
But the experience that he will be garnering out of this work order is also.
That is the satisfaction. That is the satisfaction. If they think he's not competent, they are the person who have to take the call. Who are you to say? Even your work will be adjusted by them, whether it's satisfactory or not, even if you have expertise into the domain. It all subject to his satisfaction. Get it? They have to
Giving it tomorrow? Yes.
Left over tomorrow. Item.
No.
Item 36 from today's list.